Hey guys, Evan Rachel Wood has replied to Manson's response to the anti-SLAPP motions. So remember, Wood asked the court to strike certain parts of the complaint in the lawsuit against her. Manson has responded to that, and now Wood has filed a reply. At least as far as the argument goes, that should be the last document that happens. There could be some other things on evidence, but we'll take a look at what her arguments are. So if you remember the last video I did on this, House of Dragoons, I made the theme of that, is anything Manson providing here going to move the needle? The judge seemed to be against him in the discovery order, so Manson, to me, needed to move the needle in his direction with something new. Let's see how that was in that video. Skeptical about, and we'll look at what already existed and what did he bring new to the table here that might move the needle to convince the judge. How does he move the needle? Does he move the needle? Yeah, so those are just a few of the times where I framed it that way. Well, Wood's attorney is not going to want to leave anybody hanging on this and directly responds to that and says that none of Manson's new evidence moves the needle. That's exactly what he says. And therefore, the anti-SLAPP motion to strike should be granted. So he puts it right there in the first paragraph. Hey, none of this stuff moves the needle. Is that correct or not? We'll take a look at that. We'd already done our analysis of it, or at least you listened to what I thought about it. Other people had some different thoughts on it, of course. But let's take a look at what Wood says to refine her arguments against Manson's claim that the anti-SLAPP motion to strike should be denied. So also in the first paragraph of this reply, Wood's attorney takes the tack that, hey, Judge, you already looked at this stuff in the discovery order you did, and you didn't issue discovery because you didn't think that these things merited overcoming the stay. And you gave reasons for that, which were largely based on the fact that they weren't good enough to make out these claims anyway. Nothing has happened since then. Manson provided nothing to you that moves the needle on that, and therefore you should stick with the reasoning that you had before. So we'll walk through those a little bit and talk about it. There are no great surprises here, of course, since this is just a reply, and she's only going to be rebutting what Manson said, which was against her original argument, so there's not going to be a lot of fresh things here. But generally, you're looking at two things for each of these items that they're contesting. The first is it something that comes within the purview of the anti-SLAPP statute? So something that say that's related to speech on some issue of public significance. That's pretty broadly defined. Then secondly, has Manson shown a likelihood of success on the merits based on whatever that item is? So the predicate is, should it be part of this motion in the first place? Then the second thing is, has he overcome his burden to show that he's got something here that the court should let it go forward? That's the arguments they have. The first thing at bat, according to the FBI, is the FBI letter. And Wood was the one who moved to strike that. Gore didn't do that. I haven't seen her reply yet. And she says, look, this was only used in the context of the custody dispute, and it wasn't distributed around to recruit anybody for you. Therefore, it can't be the basis of an IIED claim against you because it didn't cause you any emotional distress in any way outside the custody litigation. So the judge pretty much bought that, in my opinion, in the discovery ruling that she did. So I agree with Wood's attorney there. And Manson had come back with some other arguments to show how this letter was formulated, that it ended up involving Michelle Myers' phone number and distress that she suffered around that. But she said in that declaration she didn't see the letter herself until 2022. So I think Wood has the right side of the argument here, that you haven't shown anything new in your response to our anti-SLAPP motion that shows that this letter was distributed and used to help recruit. And since the judge said she thought that was a failure in the discovery ruling, apply that logic here and strike this out of the complaint. Now, I think Wood wins on this, and that's not because I necessarily agree with it or not, because my way of handling this would have been different than the judge's, because I would have at least granted some more discovery to test a few things on this and then make a decision on it. But she didn't do that, and she's not supposed to do it normally because the statute says that there's a discovery stay. And if you just lifted it every time somebody asked for it, then it really wouldn't be much of a stay. So I know there's some theory, some people's part that, hey, she's biased in favor of Wood or whatever. I don't know of any evidence of that, and I can say, in my opinion, that her judgment, while different than the one I would have had, is certainly within the legal parameters of the statute, and probably more what the statute would want than what I would have done, because my background is more general commercial litigation, and we don't have this kind of anti-SLAPP. You can't get discovery stuff. So I I'm tainted against the anti-SLAPP restrictions. She's not. She's a California judge. She's supposed to apply the law. So I can't say in any way that she's wrong in this. But then once you realize what her mindset is, if you want to figure out what's going to happen, you have to channel that. And if she stays consistent with her logic in the discovery order, then I do not think that Manson successfully changed the landscape on this letter to show that it was distributed in a recruiting effort against him or to pressure people to lie. I do think his team did a great job writing documents with what they had, and they make it look worse, the whole creation scenario and things like that. The declaration of Myers good for Manson's side. The arguments are good. But to the central contention, look for the fire and not just the smoke, was this shown to be used and distributed to third parties to recruit against Manson so that you could have a nexus there of the emotional distress that Manson says he has and the action that Wood took. So this letter gets created. Manson has emotional distress. How does this letter play into it? What is the evidence of that? The evidence of it is inside of the custody dispute, and the court said, I don't see any evidence that it was used outside of that. Whether it's a terrible letter or not, you got to show me some connection between the emotional distress you say you have and this letter itself. Now, that's not the same thing as, Gore or Wood talking about an FBI investigation and other things with potential accusers or victims. It's about this letter. Okay, the judge is not striking any mention of an investigation when the judge strikes this letter. If she does, she's striking the letter. And I think Wood's attorneys are correct that it didn't happen that any evidence came up in the response that Manson filed. So predicting the judge on this, I would say the judge is likely to strike it. And I think people could have different opinions on that, but I think she probably will, and that could be inside of the law. Wood's attorney also in that section takes a shot at Manson's claim of emotional distress related to the letter as being insufficient under the law. And if you remember the Halloween video, I talked about the kind of just generally what would it take for him to succeed on the claim of emotional distress, intentional infliction of emotional distress, and that emotional distress has to be severe. And Wood's attorney makes the point that he attaches that to the allegations of inappropriate conduct with a minor and other things, and not to the letter. And therefore, he only has generalized allegations of anxiety and stuff like that as it relates to the letter, and that's not enough under the law. I do think his allegations of emotional distress are fairly thin and not necessarily the most robust that you could ever have. I'm not saying they're fully insufficient, but they make a point here, again, as they attack the letter, which is you can't show it was distributed anywhere, and you can't tie any of your emotional distress to the letter. Therefore, the letter should be struck because it's protected by this litigation privilege that we've already discussed in other videos. That's not a bad argument. Next up, Wood talks about the recruiting issue, that the part of the complaint that alleges liability for intentional infliction of emotional distress based on recruiting people and pressuring them to lie is insufficient and should be struck. Of course, Manson came back with some additional text and things like that shown in his lawsuit. Some of it's redacted, and so we don't know how good or bad that is. Some of it, at least. Some of it we can see. And Wood comes at that from a few fronts. One, she disputes the admissibility of this evidence. I'm not going to go but so far down that rabbit hole. If it's double hearsay, the judge cannot listen to it. If it's single hearsay, maybe they will. It's kind of up to the judge. I look at it like this. If they had a smoking bombshell in there that looked authentic, then that would probably color the judge's thinking anyway. So I respect what Wood is doing there. I'm not going to go into hearsay analysis in this video because I think the quality of the text and what's in them are not really dissimilar to other things already in this lawsuit. And they, of course, travel along that same line of thinking, saying that these texts, first of all, it's not Wood sending them, but then second of all, they don't pressure anyone. In fact, they, for the most part, which I pointed out in the last video, they say there's no pressure to be involved. So I think the smoking gun would have been, hey, here's a text saying, if you don't do this with us, there's a good chance that you could be in danger, or there's a good chance that you'll be left alone, or some kind of something that would suggest some pressure there, some real pressure there. And I think the argument really could be that, well, the pressure is that we got to stop this dangerous person that he's alleged to be, and don't you want to help do that? If we don't have your help, he may be on the street to victimize other people. That kind of pressure. But I really think That's not there at a high level in these texts. Well, it's not just my opinion. The judge also said that she thought that this wasn't extreme and outrageous conduct. The texts that were available to her to review at the time the discovery motion was heard and decided. And I think the new texts don't change that, whether if the judge does consider them. If the judge doesn't consider them, then it don't matter. But even if the judge did, I think to me it doesn't change that. Wood makes other arguments, including that the texts that are there involving her, they don't have a nexus tight enough to a legitimate accusation of severe emotional distress for those as a result of those texts, and that there's nothing pointed out that she said that's actually false or can be proven to be false. Those are all solid arguments, but to me, I go back to what they said in the first paragraph of their reply is, you looked at this before, Judge. Did anything come up that moved the needle from where you'd previously stated your position to now? And the judge had said in her prior order, these texts don't amount to extreme and outrageous conduct. Now, it's not all the conduct. That's not what the judge said, and it's not what would be said here, and it's not what's being asked. For example, the judge isn't talking about swatting or some of the other things. This is about the recruiting and those efforts to recruit. So if the judge thought it wasn't extreme and outrageous before, I don't see what was brought up in the response from Manson that makes it that way. Like, if you already thought it was extreme and outrageous, then what Manson brought up would certainly support that and bolster it and increase the amount of evidence that supports that view. What I'm saying is, if you're somebody who didn't think that, and the judge was somebody who didn't think that, what did Manson bring in his response that would make you think, well, now this is actually extreme and outrageous, this new text here? Because the swatting and stuff, that none of that's new. And I guess I didn't see something that I thought that if the judge were already disposed against this would change the way that she thinks. So the final allegation that Wood is arguing about are the statements about the groupie video, and those were cited in support of the intentional infliction claim and also the defamation claim. And since Wood didn't make those statements, the idea would be she'd be vicariously liable for Gore having made the statements due to a conspiracy between them. And while Wood does make more than one argument in her reply brief about why the claim by Manson is insufficient, the strongest to me is the one about the conspiracy, because it is, if the statements were made, they're terrible. If they're untrue, that's terrible. And to me, that could be defamatory. And sometimes defamatory statements can be the basis for an intentional infliction claim. So to me, that claim is pretty good. I don't know how Gore's going to argue against that in her brief, because I don't see the judge throwing that out against her. But Wood has a separate argument, which is, I didn't make the statement, okay? You didn't even claim in the lawsuit that I made the statement. You didn't show that I knew she was making the statement. You didn't show that I agreed about her making the statement. You didn't show that I acted with any malice with this statement. You didn't show when she was making this statement that I did any wrongful act to help make that statement or help move it along. You didn't tie me to that. Again, my personal reading of conspiracy allegations are a little looser than what the judge decided. But again, the judge decides this within the bounds of the law. I didn't see a mistake in the judge's analysis. She knows more about California law than I do anyway. But however, having read what she said, I understood it. And I think at this point, it would have been hard for Manson to rebut that in his response. But he needed to, but I don't know that he did. And again, I just told you what Wood's arguments are. Did anybody see anything that's evidence in the response that hits at those points? Because the judge said, well, I don't see a sufficient allegation of a conspiracy regarding the groupie statements to sustain liability to Wood for what Gore did. So if you're going to hold Wood legally liable for something Gore did, then you've got to show this conspiracy and you got to show these elements. And the judge didn't see that laid out well enough to move forward with it. Now, the judge did allow discovery of Gore to take a deposition about her state of mind when she was doing that. And there are things that are in the brief, Manson's brief, and also in Wood's brief, that are redacted. So we cannot know for sure whether Manson was able to make a stronger case based on what he got in his deposition, and that's being rebutted here successfully or not. I don't know that. So it's possible that Manson may have something there that could sway how the judge thinks about it. But if he didn't get something out of this discovery with Gore, then I don't think his case got any stronger between the time the judge issued the discovery ruling and now. That's my opinion. So again, this is just predicting. The judge has not issued an order on anti-SLAPP. And reading the tea leaves is simply taking the things that she said in her discovery order and then applying them by logic to the arguments now at the time of the anti-SLAPP and saying, well, if she thought that then, why wouldn't she think the same thing now? Has she just personally changed her mind? That seems unlikely, right? Did the law change? Haven't seen that. So then the main question is, did Manson bring evidence to the table that would have changed her position on these things between the time she issued the first order and when she's going to decide this in December? So we'll just have to see. And we still need to see Gore's reply as well. And again, remember, there's redacted information that we don't know the contents of. So there are things that could persuade people one way or the other that you just don't have access to. And what are the consequences if the judge grants the anti-SLAPP motion to strike? The consequences are those things are struck out of the lawsuit, but the lawsuit is still there as regards the two computer claims, okay? And then using data and impersonating and stuff like that, hacking, that's still there regardless. Probably the defamation claim against Gore is still going to be in there, in my opinion. So that's what would remain of the lawsuit. And then the things that apply to the intentional infliction of emotional distress claim, if they're sufficient to sustain that claim on their own, then I think that claim stays in there. You know, that'd be the subject of litigation down the road. It just would be these things would be struck. But the main consequence is whoever loses gets to appeal, and that's what's going to happen. It'll put the case on ice for a year. Now, remember, if Wood wins this, the judge will award her attorney fees for having to go through this. So they'll send a bill to Manson for all the time that they're spending having to make this motion and argue about it. That's another reason to appeal it, in addition to the fact that you want these things in the lawsuit. So that's likely what's going to happen with this. There are other documents on the docket already, including objections back and forth about evidence between the parties. And I'm not going over those in this video, but the Manson cases has got all of those documents, and she's going to be analyzing them for her podcast. And when that comes out, you'll get a more complete picture than what I'm discussing here, because there is a lot of pages of documents, and she has them all. And she provided this reply to me, which I appreciate. So I would look at her analysis and run down if you want to see the whole picture of things. And she'll probably get the reply by Gore too. I imagine that's going to come soon. And I know she's also working on a chart that will explain this confidential evidence situation with the fight with evidence over in the Jane Doe case and the potential to use it in this Wood Gore case and all of that. It's a little complicated, but she's working on those things. So keep an eye out for what she's going to produce on her own account, as well as the podcast she's doing. And that's it. And everybody have a happy Thanksgiving. Thanks. Bye.